In the DC metro area, we often get asked the question whether somebody can enforce the judgment of one state in another state. And usually, the answer to the question is yes. The Full Faith and Credit Clause of the United States Constitution obligates each of the 50 states and the District of Columbia to honor the judicial acts of other states. So, a judgment rendered in a court of record in Virginia is constitutionally binding on the courts of record in every other state, and the judgment rendered in courts of record in other states are constitutionally binding in Virginia. Subject, of course, to a few exceptions regarding the jurisdiction and the power of the court to enter the judgment in the first place, and certain types of default judgments. However, assuming that the defendant appeared, argued their case, and ultimately lost, the judgment obtained in one state is almost assuredly enforceable in every other state in the country. There is a procedure that must be followed in order to domesticate a judgment, but once you have a good judgment in one state, you can follow your debtor, and more importantly their assets, around the country until you have been satisfied. As with any judgment, the ultimate question is whether the judgment is collectible. At Gross & Romanick, we have extensive experience domesticating and enforcing sister state judgments around the country. If you have a judgment that you want to try to collect, please call us at 703-273-1400 or visit our website at www.gross.com.